Hello, good afternoon. I'm Michael Davis again from Davis Abogados, Solicitors and Barristers. I'm here with my friend Ignacio Pellicer, who's a lawyer from the Valencia region with an office in Alicante. Pellicer Heredia, Abogados, very good lawyers from the Valencia region. Okay, today we're going to talk about Directive 650/2012, and this is all about Spanish wills, okay? It's all about Spanish wills and certain things that you may have heard. You may have heard some people say that people need to make a new Spanish will because there's a new law that's come out, etc., etc. So that's what we're going to talk about, just to clarify your position and so that you can decide whether you actually need to change your will or not. So I prepared a short keynote presentation, mostly so that I don't forget anything myself. And then what we're going to do is answer some questions. We put an advert on Facebook a week ago, and we received lots and lots of questions on this subject. So I think that probably the questions and answers are going to answer more than the keynote presentation. But let's just quickly go through the basics about what all this is about, and then we'll go for the questions and answers. Okay, we'll dive straight in. Okay. Okay, so here we are. Directive 650/2012. Do I need to change my Spanish will? What's all the fuss about? Okay, you've heard between 2012 and 2015, lots of solicitors wrote to their clients and everyone was talking about this issue of the directive because most English people that were residents in Spain needed to update their will. This European Union Directive gave everyone 3 years to adapt their will to the new situation, and it came into force in 2015. So what's it all about? Okay, it's all about what law is applicable to your Spanish estate if you are a foreign national. This is a very important issue because under Spanish domestic law, spouses don't receive the lion's share of the estate if there are children. In other words, a Spanish person, if they have a couple of kids, they can't simply make a will saying, I leave everything to my spouse, and if he deceased or she deceased, everything goes down to the children. Their situation is very different. They're very limited because most of the estate has to go down towards the children. So what this directive is about is to try and establish how English people living in Spain and other Northern Europeans can avoid this system of obligatory heirs, which does not work well for many of our clients. So, what does the directive say? Okay, so basically the directive is very long and it talks about lots of different things, but there are two articles that are important: Article 21 and Article 22. Which I'll leave here on the video in case you want to read them in detail. But basically what it means is this, is that after 2015, if you don't make a will in Spain and on the will you state that you want your national law to determine how you are allowed to distribute your estate, they will automatically apply the Spanish system of obligatory heirs to your estate. For example, if you are a resident in Spain and you made a will saying, I leave everything to my spouse and if she deceased, down to my children, quite normal. But on that will, you don't state that you choose your national law to determine how you can distribute your inheritance, then the Spanish system of obligatory heirs will apply exactly the same as if you're a Spanish person, and the will be partially invalid because you can't leave everything to your spouse. 2/3 have to go directly down to your children. So what the directive says is, if you are a resident and you've made no will in Spain, or you've made a will in which you haven't made a choice of law, they will apply the Spanish system of obligatory heirs to your estate. That's a big problem. But the directive also offers the solution, that all you have to do to get around this is state on the Spanish will that you make that you choose English law to determine how you can distribute your estate. And then you can go on to leave things however you like. Okay, so it's been in force since 2015. Most people have gone ahead and adapted their will to the new situation, but from various situations that we've seen recently, it's become obvious that not everyone has indeed updated their wills. There are still a few people out there. This is something that, even though everyone was talking about it for those 3 years between 2012, 2015, it's no longer the flavor of the month. People have forgotten about it, and therefore those people that didn't sort of update their wills when it was the news that was everyone was talking about, they've sort of just it's just gone by. They haven't done anything about it, and now they've got a will that could cause lots of problems. Okay. What would the Spanish? Who cares? Serious consequences for your heirs. That's why we need it. We need to care, because what happens if the Spanish law was applicable to your state? Well, as I said before, it basically means that if you wanted to leave everything to your spouse, that you have kids, you wouldn't be able to. Under Spanish law, 2/3 have to go down towards the children. That's what happens to Spanish people, and for English people with kids living in the UK, sometimes even with children from other marriages, this could be a very, very big problem for the widow or widower. What's the solution? A well-written Spanish will. So as you take your old will, you take it back to the solicitor that prepared it, and just basically ask him whether it complies with the Directive 650/2012, and that's the end of the problem. If it was done before 2012, almost for certain it won't comply. If it's between 2012 and 2015, it should comply, but some solicitors didn't find out about the new directive until sort of a year after it came into life. So there is the odd one that doesn't comply either. Just go back to your solicitor or give us a call, and we'll sort it out. So my website, you'll see davissolicitors.com, is on the top of the screen. So you can click that whenever you see this video, and basically contact us. You could also, we're in the Andalusia region. We've got offices in Mojacar, Marbella and Almeria. If you need a good lawyer up in the Valencia region, we'll have Ignacio Pellicer, that we haven't spoken to yet, but we're going to speak to him in a second, and he will do a superb job at making a directive compliant will up in the Valencia region. So with that, I won't bore you anymore. We're going to go straight into the questions and answers. As I say, we've got lots of them, so I think let's just run through those and everything will be clear. So let's just stop sharing the screen, and here we've got Ignacio now with us. Ignacio.
Hello, Michael. Good afternoon.
Okay. Ignacio, well, it's the delicate subject of Directive 650/2012. As we mentioned in the video, this isn't an issue that is as problematic as it was before, because most people have now got wills that are compliant with directive, but there are still the odd cases that are sort of have somehow slipped through the net, and they're still out there with wills that could become a problem in the future. So should we just go through, Ignacio, the different questions we've got through on our Facebook stream, the live stream on Facebook? So maybe we could just go through them, and either you or me answer them as on the go.
Michael, I just say that from the last time you did the post, we've been inundated with questions here.
Okay.
About wills, and so shall we go through it? Because I did select the most important ones.
Okay. Let's go for them. Try and make them easy, Ignacio. We don't want
okay. Right. Okay. I think that's perfect, because it's in your area, Michael. I've got one here from the Facebook page saying, I live in Marbella with my husband. I wish to leave everything to my husband and then to my children. Can I do this? Michael?
Okay, well, this is very straightforward. She lives in Marbella, resident in Marbella. She could make a will, leaving everything to her husband and then down to her kids without any problem. She just needs to make sure that she puts into her Spanish will the clause that conforming to Directive 650/2012, I choose my national law, which is English law, to determine how I am allowed to distribute my estate. And with that, you just go on and make a normal Spanish will with those wishes. Very straightforward.
Perfect, Michael. I've got another one, and he's in your area as well. It's in Mojacar. He says, I'm a non-resident, but resident in the UK. My husband has 2 children from a previous marriage. He made a will, leaving everything to me, but has not placed a clause in the will. Does he have to?
Okay, well, that's a more challenging question. Now, the answer is this. Technically, they don't need to make new wills for a very simple reason, and that is that what the directive says is that if you don't make the choice of law, they will just apply the law of your nationality. Of your last residence. In this case, the residence in the UK, so English law will be fine. It will be applicable anyway. Now, we have to take this with a bit of pinch of salt, and now. So the simple answer is, even if you're a non-resident, make the will with the directive choice of law. Why? Because what if there is a doubt regarding where you were a resident? For example, some people live in Marbella, they're non-resident tax-wise, but when you look into the paperwork, they've joined the padrón. It's an indication of residency, not 100%, but it's already. I say this because in her case, she talks about children from another marriage. So if her husband passes away, she goes to inherit if the clause is not in the will, the notary will ask her to prove that she's a non-resident of Spain and resident in the UK. If she can prove it and she feels comfortable that could not be challenged, that is fine. But if there's any doubts, because she spends a lot of time in Spain or they've joined the padrón and things like that, then then I'd recommend making the choice of law anyway, because otherwise the children could challenge on the grounds that they reckon that their dad really was a resident in Marbella, and it could become debatable. Okay, because remember, if the children can prove or they indicate that the father was in fact a Spanish resident, and the choice of law has not been made, it will be the law of the last residency, and under Spanish inheritance law, the father would be entitled to 2/3 of the estate. In other words, in this case, the answer is vague, because technically, a solicitor could say to her, no, you don't need to, because he's a non-resident, it will always be English law. But with the children from the first marriage, I think it's money well spent to make a will, making an express choice of English law, even though technically it's not necessary. Have you got any more, Ignacio?
Yeah, there is a few more here. It says, this is in the area for Benalmádena.
Okay.
I'm a widow living in Benalmádena, and my husband has deceased. My will leaves everything to my children. Do I need to make a new will? Michael,
no, she doesn't. She doesn't, because at the moment her husband is no longer with us, so everything's in her name, because I imagine they've already gone to probate. And as she's got no husband, she's left everything to her children. That would work under both Spanish law and under English law. So it doesn't matter. She doesn't need to she doesn't have to have a will compliant with the directive. It's not necessary.
Perfect. And I've got another one here, Michael, saying, I understand that England and Ireland have opted out of the directive. Does the directive still affect me?
Yes, the situation is exactly the same, because what happened with this directive is that all the countries in the EU ratified it, except for England and Ireland. But the countries have all agreed to apply it regardless of reciprocity. What does that mean? Well, even before England left the EU and all these things, if an Australian person came to us and bought a house in Benalmádena or Marbella or anywhere down here on the coast, when they made a will, they were allowed to choose their national law, Australian law. Why? Because Spain applies this directive regardless of reciprocity. It doesn't matter that Australia is not part of it, and it doesn't matter that the UK is not part of it. It never has been. And after Brexit, the situation will be the same. We mustn't confuse the issue of inheritance tax, which could change after Brexit. As far as who you can leave your assets to, you need to make a will that's compliant with directive, and Brexit doesn't affect it.
Great, Michael. We've got a few more here. Let me just try to run through it. It's important because now with the Brexit, will the Brexit change everything again?
No, it's the same answer as the last one, Ignacio. As far as to the directive, it makes no difference, the choice of law, because England was never part of this directive in any case. So it's the same before as after. Again, people mustn't confuse this with inheritance tax, which is a completely different issue, and certain things may change after Brexit. Okay.
Good, thank you, Michael. Another important one that I have selected from so many, because we're being inundated, Michael, with questions. Do I have to make a new will, or can I simply make an amendment to the existing one? Does this mean that Spanish inheritance tax is not applicable?
Sorry,
can you help me? Does this mean that Spanish inheritance tax is not applicable?
Okay. Well, there's two questions there. One is one is regarding the amendment. No, unfortunately, you can't make an amendment to a Spanish will. You have to make a new one, revoking the previous one. And before people get upset, because they have to pay a full solicitor's fee again, most solicitors, if you've done a will within the last 8 or 9 years, they will have the text on their computers. So most lawyers that I know will do a new will for you at a reduced price, because even though they have to be re-registered and signed at the notary the same as the last time, and technically you have to sign a new will to revoke the previous one. If they have it on their systems, it's just a question of basically updating your passport that may have been revoked, add in the directive, and maybe a change of address if you change your address. So most lawyers that I know that deal with estates do some kind of discount for doing a will to revoke the one, just to add the directive. Sorry, you said something else about the inheritance tax. Okay.
Does this mean that Spanish inheritance tax?
Yeah, the choice of law is only to the extent of choosing how you're allowed to distribute your estate, and it has no effect over inheritance tax whatsoever.
Great. I think pretty much, Michael, that's...
okay, well, I've got a couple of questions here as well for you. So
all right.
I'm just trying to find where they came through by email, and Estefania's resent them to me, and I have got them here. Okay, this is a client from Ciudad Quesada. Ciudad Quesada, I think that's in Alicante, isn't it? That's in...
Yes, that's right. That's in the south part.
Okay. It says here, how long does it normally take to prepare a Spanish will for expats? I think enough, you just answer it from your point of view. In your office, how long do you normally take to organise wills?
Right. Okay. Well, the answer is straightforward, because it will depend how complex is the will. But
that's a terrible answer, Ignacio.
But basically, Michael, if they send us the form, normally it will be pretty much straightforward. So they send us the form. Well, we send them the form. They fill in, send it back to us, and then we can organise during the same week a completion date, so we can legalise a will. Okay. So that's basically what we will do. Now, Michael, this is, I must admit, this is for wills that are reasonable, straightforward. If we're making a very complex will, because we need to do it in Spanish and English, and then agree with the notary, because you know how these things work, it will take probably a bit more to think about it. But how about in your area, Michael? How do you deal with it?
Okay. Well, in our area, I mean, 80% of expats living in Spain that have like a property, a bank account, and a car, maybe a couple of investment properties, and they've got children. And nowadays, with the very large exemption rates that we have down here in Andalusia, normally you don't need a complicated will. 80% or 90% of our clients need a very straightforward wills, and it's the best for them because unless there's a serious advantage for inheritance tax, one has to always keep away from complexities. That's my after handling many probate cases, as you know, Ignacio, I am completely against complex wills. Okay,
that's right.
So basically, in our case, in most situations, we like to meet with the clients first, and then we normally organise for the signature of the will 1 week later. Up to now, we always insisted on meeting the clients in one of our 3 offices, Mojacar, Marbella, or Almeria, because we do like to meet the clients at least once before we do anything, to fill in the data protection forms and all these normal things. Also, just to get to know them and maybe have a look at their title deeds and make sure everything else is in order. We've changed that slightly. Since the coronavirus, we've discovered Zoom. I know you do a lot of Zoom as well. And we can now do the first appointment by Zoom if the clients prefer, and to avoid them coming in twice. We found also, Ignacio, that the Zoom has a great advantage, and that is that sometimes, especially with clients that are more elderly, a family meeting is sometimes a good idea with the children and sometimes even with their family lawyer in the UK, if it's sometimes to coordinate things. And Zoom allows this to happen very easily. While before, to organize, the son to come over and help his mum and dad out and organize things a little, it required them coming over. Now, I mean, we offer the appointment, and we're very happy to send the link out also to perhaps their children in the UK, and then we can have a real family meeting to discuss the wills without everyone having to move around. We found it an excellent solution. And I know, Ignacio, that you're also doing the Zoom appointments, aren't you, for things like wills?
It's a fantastic way, Michael. And as you said, most of the wills could be sorted out with a conversation. Now Zoom really gives a very handy tool, so you can speak to the family. And I think you brought an excellent point here, because it could be sorted through a video conference, and then the will could be signed as soon as everything could be agreed. So yes, video conference is a success, Michael.
I mean, we've got a standard sort of procedure, which is the one that we handle for most of the wills. I mean, we've got the wills that for clients, they've done the conveyancing through one of our offices. That basically we sign them on the same day that we complete, or as soon after as possible. With clients that are just coming in for the wills, what we do is they contact us, we send them our form, they fill it all in. With that information on that form, I send them a budget. If they agree with it, we set up the appointment, okay, which at the moment, we've got about 10 days. 10 days is probably the time that it takes us to grant someone an appointment on average at the moment. And basically, that appointment would be either by Zoom or in one of the offices, and then we'd automatically agree that day to take down their details and go through any questions they have about inheritance tax and the procedure for probate and things like that. And then we'd always organize the signature at the notary for 1 week later. The day that we sign at the notary, we always ask our clients to wait around for 10, 15 minutes after the signing, so they can actually take away their will with them on that day. That's sort of the procedure. I mean, it's very straightforward. There's nothing complicated.
I agree, Michael. Most of the wills we have signed so far has been pretty smooth, pretty good, and I think I recommend everybody to have at least a will straight away as soon as they buy a property in Spain. I mean, unfortunately, some clients do not still have a will, and it's quite worrying, Michael, because the probate, I'm sure you've been through the probate, complex probate, of interstate law, different applicable laws, and I'm sure you want to avoid that, don't you?
Absolutely. I mean, here we're talking about, about the directive and how the wills have to be compliant. So you may have to revise your will, but I mean, we can't stress enough how important it is to have a Spanish will, and even more so after the directive. I mean, if you at the moment die in Spain, you're a resident in Spain, and you die in Spain, you have to go through an intestate procedure in Spain, applying the Spanish system. And under the Spanish system, the children are the next of kin, not the spouse. The children get the lion's share of the inheritance, not the spouse. And if you're a resident in Spain and die without a will, choosing your English law, what will happen is that it's the Spanish law that will kick in and apply to your estate. And it causes lots of problems. As you say, Ignacio, it's which law is applicable. If a Spanish person dies in Spain, it's not so much of a deal, because we all know what law applies. It's Spanish law. 2/3 go down to the kids, 1/3 across to the spouse. Okay. When an English person dies, it can get very complicated if you haven't chosen on the will which law is applicable and then distributed the estate yourself, because you get all this situation of which one is applicable to this estate, and you've got the issue of jurisdiction, the issue of legislation that's applicable, and estates can get complicated. I'm saying this from experience. I mean, I've been handling probate now for 25 years, just over. 1994 we started. We must have done 400, 500 estates just myself personally. And without any doubt whatsoever, you need to make a Spanish will, and you need to make sure it complies with directive. I don't
Michael,
know. Have you got...
I just would like to just point out the importance of choosing a lawyer who's expert like yourself in the field. Because, Mike, I don't know if it happened to you. I've seen in some situations where people go with their translators, and sometimes it's quite worrying because the translator could only translate, but it cannot really get into planning, Michael, about the applicable law or even about taxation, because some people are distributing things with a translator. So it's still quite scary, Michael. Have you seen that situation as well?
Yes, not very often done by translators, but we have we're the biggest problem. You know, the majority of the problems come from people that haven't made a will, and then people that have made a will but it's not compliant with the directive, done by solicitors but done many years ago. So I mean, they're not to blame. It's just that they haven't been revised. That's the majority of the problems. Then the other big field of problems for us that we see is people that have made an English will for worldwide estates, mentioning a trust that don't exist in Spain, and we're having to convalidate. Those can work out extremely expensive and long, the procedures. Yeah, I mean, there's no doubt. I mean, it's just, you know, a will is just such an important thing. I mean, also, it's how much does a will cost? A lot of people are confused about this, and we've seen non-professional, well, so, you know, mostly solicitors, but they've done the conveyancing. I mean, at the end of the day, to handle to handle your will, it's preferable to use a lawyer that does probate, because we've seen very complex wills written by lawyers that have never gone to probate, and of course we end up with this complex will that all sounded, you know, theoretically looked all very good, but then it's all ended up in a mess. So I think that's the question. If somebody tries to sell you a complex will, the question that you need to ask the lawyer is, has he ever gone to probate on a will and got tax clearance on a will like the one he's proposing? Because if the answer is no, I would definitely ask for a second opinion. And going back to what things cost, from what I see, most of the lawyers that deal with inheritance and wills charge amounts that are very similar to non-experts. I mean, a couple of wills in dual columns, with compliant with directive, registered, with everything in good order. Most of the lawyers that we know that do a good job, we're all charging anywhere between, for a married couple, it costs about between 600 and 800 euro for the two wills, including the notary fees, including the VAT, and including the registration. That's, you know, roughly 600 or 800 euro for wills. The wills would have to be extremely complex normally for them to cost more than that. I mean, that covers 90% or 99 or 95% of the wills that we do. What are you charging up there in Valencia, Ignacio? Is it more or less similar? Or?
Yeah, Michael, that's pretty much the same. Actually, it clicks with your figure, because normally will be an average of that 800 euros, including notary fees, solicitors fees, VAT, and obviously that includes assistance to the notary with the lawyer. So yeah, we're pretty much similar, Michael. I would like to bring you later on a question about executors, because it just came through. Do you think it's a good idea, Michael, to mention your trusted lawyer as an executor, or what do you think?
Well, it depends. It depends, Ignacio. Most of our clients that we've known over the years, the ones that we've got a relationship with, normally name us the executors. And then we, because of, you know, internet and things, we do a lot of wills now for clients that we've never actually met before. So they're up in Madrid or Barcelona or whatever, and so we haven't got any previous relationship with them. And we don't normally insist too much on the business of executors, because first there's no sort of relationship with that person from previously. And it causes us certain concern because of the money laundering compliance rules and all these things that, you know, are getting very complicated. And being the executor of an estate of somebody that we've had no previous relationship with in the past, it doesn't make us 100% comfortable. So in our case, we're executors of about 80% of the wills that we've signed over the last 25 years. Sometimes on our own, sometimes jointly with a family member, and sometimes even jointly with their family lawyer in the UK. That is basically only recommendable on large estates, because it does increase the expense, because obviously when we go to probate, the English lawyers going to be coming over to Spain, and of course we'll be billing them for that time. Likewise, funnily enough, over the years, even though we've had English people here when they've moved back to the UK, and we've actually been named joint executors of wills in the UK on English assets, because the clients actually, after spending 20 years in Spain, they actually had more of a relationship with us than with their lawyer in the UK. When we've been named executors of inheritance in the UK, normally we insist that they always name us jointly with somebody in the UK, because otherwise it becomes complicated to deal with things because of the amount of times that you may have to visit the UK and things like this. Even better if it's a solicitor in the UK. So I think that's it, Ignacio. I think we have to wrap this up now. If you could just tell everyone, please, where they can find you, what's the easiest way of finding you if they need to make a will up in the Valencia region. What's the best way of getting hold of you?
Okay, well, the best way to get through, it will be through a website, which to remember probably will be alicantelawyers.es, which is easier, Michael, than pellicerheredia.com for the English community. And then I think that's the easiest. They send us an email, we can send them the forms, they fill it in, we do a video conference still if it's not possible by COVID or any other reasons, or they're in a different country. And then we could agree on a date to complete exactly as you described.
Okay, Ignacio, could you just tell us very quickly where your physical offices are situated? Just what area, not the full address, just where are you exactly? Where do you have offices?
We cover the whole Costa Blanca in Alicante province, and you could go from South Alicante, which is Ciudad Quesada. You could go inland. We've got Hondan, Petrel, and then we've got in the centre of Alicante an office. And through all the north part of Costa Blanca, we've got Moreira and Javia and Denia. So we pretty much, Michael, cover Alicante
Excellent.
province in such.
Excellent. Okay, well, in my case, for those that don't know me from before, I'm Michael Davis from Davis Abogados, Solicitors and Barristers, and we have offices in Almeria, Mojacar, and Marbella. And that's about it, really. For those that are watching this video on YouTube, please subscribe by hitting the subscribe button below, and we will keep you informed of all legal matters affecting expats in Spain. Thank you very much for watching.
Thank you very much, Michael.
Thank you for coming along. Bye.
Thank you.
Bye.
Bye-bye. Bye-bye.